Hello, everybody. Happy Friday. TGIF. Thanks for joining us tonight. Welcome to Children of Darkness and Light. I'm your host, Lori Hellis, the good Lori, and I want to just say welcome to all my good friends. I'm going to chat a little while. I wanted to talk a little bit about what the format is today. We usually reserve Fridays for the Vallow-Daybell case, and we're going to talk a lot about the Vallow-Daybell case. But this latest case going on in Idaho with the University of Idaho students and Bryan Kohberger, there's some really interesting information that I don't want you all to wait till Wednesday to talk about. So we're going to talk about it tonight. And just a couple things. I want you to know we are going to talk at length about some of the new developments that are going on in the Vallow-Daybell case. But I am going to start out with a little bit of information on Bryan Kohberger and the University of Idaho case. What I like to do is I like to fill you in on all of the latest occurrences and the latest filings and all of the latest things that are going on, and then open it up for questions. Because we're going to be talking about both cases tonight, I expect that we're going to go a little bit longer than the hour, but don't feel obligated to stick around if you need to pop out after the hour's over. And you can always catch the end of it on a replay. So after I tell you about some of the developments that have happened, then we're going to open things up to questions. And it would be really helpful if you would, for our moderators, if you would hold your questions until we get to that point. And if in your post, you would start your post with question, the word question, all in caps. That will really help our moderators be able to identify your questions. I hate the idea of suggesting to y'all that you need to make super chats in order to get your questions answered because they're much easier to see in the chat. We're not asking you to do that, but if you just write all in caps, the word question, that will help us pinpoint those questions and we won't miss them. Our chat moves pretty quickly, so we want to make sure that we're not missing things. Our two moderators are here tonight, Brenda and Michelle, as always. I want to remind everybody that if you are of a mind to donate, and we have some really generous followers in our chat, and we appreciate it a lot. If you are of a mind to donate, all of those super chat donations go directly to our moderators, because I couldn't do it without them. So I want to talk a little bit tonight about, oh shoot, I had all my slides set up here to show you, and in messing around and going in and out of the chat, I dropped my slides. So bear with me and we'll get those up for you. We're going to talk a little bit tonight about Bryan Kohberger. He is the person who has been arrested in the Idaho University of Idaho in Moscow, the murder of 4 college students, one male, Ethan, and 3 women in their home in the dark of night. The 3 women are Madison and Kaylee and Zaina with an X. I'm going to just do a little bit of a recap. I know we talked about this case quite a bit on Wednesday, and so I don't want to be overly repetitive, but for those who haven't been following the case or who weren't with us on Wednesday, let me just give you a little bit of a recap. He is a 28-year-old graduate student. He is a graduate student at Washington State University. Now, Washington State University and the University of Idaho are about 8 miles apart. They are across the Washington-Idaho border. I know I misspoke last time because I was still getting over my colonoscopy. So sorry if I was a little dopey. It is across the Washington-Idaho border. And that is the two schools are almost like sister schools. Washington State University, or Wazoo as we call it in the Northwest, is in Pullman, Washington, and Moscow, Idaho is the home of University of Idaho. Bryan Kohberger grew up in Pennsylvania. He went to community college there where he got a psychology degree. He finished a bachelor's degree at DeSale University in Pennsylvania, sorry. I kept trying to say Philadelphia, and that wasn't right. Pennsylvania. And he then went on and got a master's degree at DeSales University in Pennsylvania. His undergraduate degree was in psychology. His master's degree was in criminal justice. He was pursuing a degree in criminology, an advanced doctorate degree in criminology at Washington State University. One of our listeners asked, what's the difference between criminal justice and criminology? I think I'd have to say that criminal justice is much more about the workings of the justice system, and criminology is more about the technical side, investigatory sorts of technology. So I'm so sorry. That's what happens when you choke on your wine. That's it. Cutting myself off. So, I'm so sorry. There are some developments in that case that are really interesting. Kohberger was arrested in Pennsylvania where he was home for the holidays. And he was very promptly, he waived extradition and he was very promptly brought back to Idaho. He had an initial appearance where the judge read the charges to him. And at that point, the probable cause affidavit was unsealed. So Wednesday, the probable cause affidavit was unsealed, and we all got to look for the first time at the investigation into his crimes. What is absolutely fascinating is that the whole time that the Moscow police were sort of diverting attention and saying we don't have any suspects, they had been following this guy. They knew who he was. They were collecting his cell phone data. They were collecting his GPS data to track his movements in his car. They knew what he drove, which was that white 2015 Hyundai Elantra. they had far more information than they let on when they were asked about the progress of the investigation, which is why it led a lot of people to the conclusion that the case had gone cold. So what is really interesting is that during the whole time that he was, from the time the crimes were committed on November 13th until he was arrested, he was trolling around in all the online chats. In particular, he was involved in one of the biggest chats that was Facebook groups devoted to the case. And he was posting as this guy. He was posting as Papa Roger, and you can see that he has an artificial intelligence cartoon drawing of himself. I think it's particularly interesting that he's in some sort of a military uniform. It almost looks like a German or a Russian uniform of some kind. But it's very clear that this avatar is him. So there he was in the chats having conversations with other people about the details of the case. And you'll see, and his account was disabled on the day he was arrested. So there are some very interesting posts that he made in that in that chat. So let's take a look at them. Well, first of all, I want to talk about his name. So his name seems to have been pulled from this fellow, Elliot Rodger, spelled the same way as he spells Papa Roger, and became a hero in the incel community. Incel means involuntarily celibate, meaning that he was striking out with the opposite sex. His target was beautiful sorority girls from Alpha Phi, and Kaylee was also a member of Alpha. I think it's Phi, Alpha Phi. So that is somewhat interesting to know that he was naming his online character after that. But what I found especially interesting was he got into the chat and he began talking about, and I apologize if these aren't big enough to read, but he says, of the evidence released, the murder weapon has been consistent as a large fixed blade knife. This leads me to believe they found the sheath. Now, to the average person in a chat, that makes absolutely no sense. And on in the chat, people comment about, that's just a weird theory. But in fact, he was the only person who knew that sheath had been dropped. So they go back and forth about the sheath is usually attached to a belt. They sort of go back and forth about talking about this sheath. And in the end, he gets a little bit testy with one of the posters who says, if we find out one day and I'm wrong, I will gladly eat crow, he says, because he knows he's right, because he only he and the Moscow police know for certain that he dropped a sheath. And it goes on to say, dude, give it a rest. You sound like a psycho. Because he is talking about, he says, oh, I'm up here. He says, I'm really sorry that nobody's buying that sheath theory of yours. And in fact, he did know that, that a sheath had been found on the scene because he dropped it. So there are some other very interesting parts to this. Whoops. Sorry, I thought I had adjusted that slide so that it was right side up. So let's try this one. It's interesting that he makes the comment, regardless of what has been said. I believe this is a sexually motivated crime, which is somewhat interesting because law enforcement had been quick to point out that that there was no the victims were not sexually abused. But he follows it up then with this question. Do you think the killer has a sexual dysfunction? Which is sort of interesting. If in fact he is talking about himself, I think that is an interesting question when you add that to the question of whether of him naming himself after a famous incel. So someone who was involuntarily celibate. It's very clear from this that he was trolling these chats for days and dropping little hints about knowing things about the case, such as looking at a diagram of the property and putting a pointer on where each of the bodies were. These are very troubling. These are very troubling facts that only at the point that he was making these posts, only the murderer and law enforcement would actually know these facts. So the part about the sheath is very eerie because it was indeed the snap on the case on the sheath that yielded his DNA. And so that appears to have been a pretty big mistake on his part. So as this case moves forward, I'm sure we will continue to see more information, and I'm certain that we will see law enforcement looking back at all of those posts that he was posting on social media. So there's another part to this. When the probable cause document was released, one of the things that people were curious about was the fact that their roommate, who in the sorry, don't mean to give you whiplash, but I'll pull those up in just a second. I wanted to explain. When the probable cause affidavit was released, one of the roommates, it became clear that one of the roommates who was in the basement heard a noise. Initially, she heard noise that she thought was Kaylee, her roommate, upstairs playing with her dog. Then she heard some odd noises. She heard what sounded like a whimper or a scream, and heard a male voice say, "It's okay, I'll help you," or something to that effect. And then heard another big thud and a scream. And at each of those instances, she went and opened her door, looked around, didn't see anything, closed her door. Now, remember, these are college students. There's lots of activity that goes on in an apartment full of 4 college girls, or 6 college-age girls. And they also had all been out drinking. So we don't know to what level any of them might have been intoxicated. That's not in the probable cause statement. We don't know whether it's in any statement at all. And a lot of people have been, the probable cause affidavit, then her portion of it ends when she hears a noise. She goes to her bedroom door. She sees a man all dressed in dark clothes. She estimates he's about 5'10", kind of an athletic build and with bushy eyebrows, and he's got at least a partial mask over his face. At that point, she's frightened. She's kind of frozen. He rushes down the hall and out the door, and she then goes back to bed. Now, that is the point that a lot of people have asked about. A lot of people have said, where were these roommates? How come it wasn't until noon when somebody called and said there was somebody who was unconscious? How did they not know their roommates had been murdered? Why didn't they call the police? Why didn't she call the police? And I came across this post, and I think that it is important for us to remember that we take witnesses from where they are at. We don't get to pick perfect witnesses. We have to take witnesses from where they're at. And I really hope that after you hear this, that you'll be able to sort of dispel some of this online bullying that's happening toward this roommate. Her name is Dylan. So this is a post, and it says, the call was made from Dylan's phone, but a male friend, also a fraternity brother, is the one who spoke to 911. Dylan actually fainted outside in the front yard. So he took the phone. He had not been in the house, didn't know why the 911 call had been initiated. And so all he did was say to the person on the other end that a person had passed out. At that time, he didn't know what had happened inside the house. He was talking about Dylan, who had fainted on the front lawn. So that's the first piece of it that I think a lot of people needed to hear and understand. And then the second piece of it is this. I also know that she was very confused about what she had seen and heard. I don't want to give too many personal details, but she suffers from PTSD due to things that happened to her in her childhood. So as she has extreme nightmares and panic attacks often at night. She told the friend who made the 911 call that she thought she saw someone in a mask in their house, but she wasn't 100% sure it wasn't a nightmare. That's why I feel as awful, so awful for her. I'm sure she will beat herself up for the rest of her life. But knowing her situation and what she has been and that they had all been drinking that night, I 100% believe that she was in shock. So I think that it's important in these cases to remember that we don't have all the information. We don't know what actually went on in that house, but we know a little bit more now. We know that when Dylan, who quite honestly told police what she had seen, first saw it, she wasn't sure if it was real, and wasn't sure whether it was a product of her panic attacks and her nightmares. So I just encourage folks to think through those things and to be critical viewers when it comes to and critical thinkers when it comes to these cases, because we don't have all the facts, and we have to remember that that these are real people and that we're taking them where they are when these incidents happen. So those are some interesting things going on with the Kohberger case. He is scheduled for a preliminary hearing on January 12th at 10 a.m. He's being held on a no bail hold. And I had a listener who asked why he hasn't been charged with capital murder. In Idaho, the process is that you are charged with first-degree murder, and then within 60 days after the indictment, the prosecution must determine whether or not they intend to seek the death penalty. You'll recall that happened in the Vallow-Daybell case. They were indicted, and then sometime later, the district attorney filed the notice of intent to seek the death penalty. So we won't know for a couple more weeks, probably a couple weeks after the preliminary hearing. Now, if you recall, preliminary hearings are more commonly used in Idaho than grand juries, but either process can be used. And if you recall, in the Vallow-Daybell case, the initial charges, they held a preliminary hearing. They were both scheduled for preliminary hearings, and in fact, Chad had his preliminary hearing, and then Lori waived hers. So when it came time to indict them on the murder charges, those facts were presented to a grand jury, and the grand jury handed down an indictment, and there was not a preliminary hearing. So let's move on to Vallow-Daybell, because I want to leave us with plenty of time for questions. Please subscribe. Please hit the like button. Please, if you are going to post a question, hold off until we ask for them. And if you post a question in the chat, please start it with the word question all in caps. That's just going to make it so much easier for our moderators to be able to spot your questions. So I had a couple of people who asked me some questions about another creator who is circulating a petition for cameras in the courtroom, and whether I thought that would be effective. I don't suppose it will hurt, but I would be very surprised if that had a lot of impact on Judge Boyce. I know that Judge Boyce knows that the public wants to see this trial. And I know that there are a lot of folks who feel like that they are entitled to see this trial. I also know, and much more concerning, is the fact that it is going to be a real hardship on the families, both the families of the victims and the families of the defendants, for them to leave their homes, some in Louisiana, some in Rexburg, some in Utah, some in Arizona, and be able to travel to Boise and potentially be here for 3 or 4 months. Now, at this point, they have forecast that the Vallow-Daybell trial is going to take about 10 weeks, but that does not include the penalty phase. So we could be looking at another month's worth of testimony in the penalty phase. So I do know that I think that it's very important that family members reach out to Judge Boyce. I've offered to provide and have provided to some family members the proper address and the way to get those letters to Judge Boyce. I think it's very important that people who are directly related to the case let the judge know what a hardship it will be if the case isn't live streamed. I've said before, I think maybe there's a 50-50 chance that he may change his mind when it comes to live streaming the trial. But my observation is that Judge Boyce doesn't appear to be the kind of judge who changes his mind and backs down very well, which comes into play in some of our other conversation. So there have been a bunch of filings in the Vallow-Daybell case. So first of all, we had Lori Vallow's attorney, Jim Archibald, who has said repeatedly in trial and in court that we were going to hear about Lori Vallow's mental health diagnosis at trial. And repeatedly said that Lori's mental health would be an issue at trial. So it was pretty surprising when a couple of days ago, I want to say it was the 3rd, Jim Archibald filed a notice saying that they do not intend to seek to offer a mental health defense. So what he said was she has consulted with 3 different mental health professionals. She is competent and is aiding and assisting in her defense, and that Lori has said that she does not want to offer a mental health defense. So it's important to remember that lawyers are required to follow their clients' instructions. So in the case of Archibald and John Thomas, they are required to follow her direction. And if she says, I don't want to offer a mental health defense, they can't do that over her objection. The single thing they could do would be to go to the court and say, we think she's not competent to make that decision, but it's clear that she is. Let's remember that in late September, early October, they filed motions and filed ex parte affidavits with the court, expressing their concern about her ability to aid and assist, her level of competence. And she was reevaluated. The judge then held a closed evidentiary hearing on the issue. And after all of that, determined that she was, in fact, competent to proceed. So I think there's some things of interest in that notice, including the fact that she has been evaluated by at least 3. He says the defense has hired 3 experts who have weighed in on her competence and her mental health. It's interesting, and we have to at least speculate a little bit. It's interesting that Dr. Michael Wellner, who was the forensic psychiatrist who determined that David Bryan Mitchell, who was Elizabeth Smart's kidnapper, was malingering. Mitchell had been convincing people that he was not competent to proceed, not fit to proceed, and for quite some time, years. And it was Dr. Wellner spending an extended period of time with him that led him to determine that Bryan David Mitchell was malingering. So it's interesting that Dr. Wellner, we know that Dr. Wellner was involved in some way because his name is in a caption on one of the documents that was sealed. So we know that he was somehow involved. We don't know to what extent or what he found, but it is interesting that his specialty really is proving malingering. And it appears that he at least was asked to be involved. We don't know whether he was directly involved or not. So the other thing that, the other filing that happened last week was John Pryor complaining about the dates that the judge had set in his scheduling order. It's very common in complex cases, death penalty cases in particular, for a judge to sit down and say, here are your deadlines. Here is when all of the jury questions have to be in. Here's when the last of the discovery has to be in, and the judge really sets out a schedule to make sure that things are on track for trial. So the judge had said that jury questionnaires the questions needed to be submitted from the defense to the court by January 9th. And John Pryor objected to that, claiming that he has not completed his mitigation work and that he really needs to know what his mitigation theory is going to be before he knows all of the questions to ask his jurors. Now, that may be true. It may very well be true that he needs to be able to formulate jury questions based on his mitigation theory. Makes perfect sense. The only problem with that is he's known for 2 years that this was a death penalty case and that he was going to need a mitigation specialist. It has only been in the last 3 or 4 months that we know of that she's had a mitigation specialist that's been working on the case. Likewise, we've known for quite some time that this was a death penalty case and that John Pryor was going to need help, and that, like Lori Vallow, he should have a team of attorneys, at least 2, and an investigator and a mitigation specialist. And it has only been recently that we have discovered that that in fact Brandon Hobbs, who is known in the legal community, has come on as the investigator, and Mary Goody has come on as the mitigation specialist. Both of them quite experienced and quite capable, but they haven't had a lot of time to do their jobs. Contrast this with the fact that in Bryan Kohberger's case, he was waived extradition and was picked up the following morning to be flown to Idaho. And by the time he was picked up at the prison in Pennsylvania, his defense attorney, Ann Taylor, and her team were already touring the crime scene. They were already present at the crime scene. She already had her crime scene reconstructionists there. They were taking measurements, taking photos, not 24 hours after she was assigned to the case. So that is a huge contrast to the fact that we have that we have a defense attorney who is claiming that he is unable to meet his obligations because he doesn't have enough help. So dovetailing onto that, in that motion complaining about the deadline for jury questions, he indicated that he has now hired a second attorney, and that attorney requires time to get up to speed. He says there's no way I can be ready by April 3rd, and asks the court to continue the case. He recently, I think it was yesterday, filed a formal request for a continuance in the case on the 3rd of January. So he filed this official continuance, this official motion for continuance, and he's asking the court, once again, asking the court to set the case out into fall of 2023. So, as we've talked about before, this puts Judge Boyce in a really awkward, rock and a hard place kind of a position, because Lori has not waived her right to a speedy trial. And what that means is, according to her attorney's calculations, her trial must begin no later than February 21st. So the judge has now set the trial on April 3rd. So he is a month and a couple of days, maybe a week, over what her attorneys believe is the deadline. However, the statute does say that the judge can exceed the maximum time if the judge finds that there has been good cause. Now, I think the judge has got a good argument to say, hey, there's good cause, because we have to deal with an out of jurisdiction county that we have to accommodate their docket as well. So April 3rd was as quickly as we could reset it in Ada County, because we had to take their docket into consideration. So I think he probably survives an appeal on that brief delay because of Ada County scheduling. There's no way he survives an appeal if he continues the case until October. So John Pryor is arguing, my client's not going to have effective counsel because I can't be ready in time. I can't do all the things that are best practices, the ABA says are best practices, between now and the time the trial starts. I can't do all those things. Even if we worked around the clock, he says in his motion, we couldn't do it in time. So now we have to look at which is the weightier objection? What is the worst consequence? The worst consequence if the judge denies Pryor's motion, excuse me, if the judge denies Pryor's motion and tells tells Pryor he's got to go to trial on April 3rd, he's going to file a motion and he's going to say it was per se ineffective assistance of counsel because I was a one-man shop. I didn't have any help. There was no way I could be ready for and have completed all of those best practices tasks before the trial. And he's going to say, my client was prejudiced by that and he deserves a new trial. So we have to take a look at, first of all, at how likely it is that Chad could win that kind of a challenge. And what we do is we have to look at former case law. And there is the seminal case, the case that cites the rule is Strickland. And Strickland says there's a two-part test. Courts are just absolutely hooked on two-part tests and three-prong tests. And so it's very common. So the first part of the test is, did the attorney fall below the reasonable standard of performance that you would expect in that attorney's circumstances. So it's not something that's reviewed in a vacuum. A court is going to look at it and say, would a reasonable attorney in this attorney's situation and under those same facts, would a different attorney be able to provide any better representation? And I submit the answer is no under the current circumstances. Now, I think it's very possible that a court could say, look, Mr. Pryor, you had 2.5 years. You had 10 months while Lori was in treatment. This is ridiculous to think that you've had all this time. It's ridiculous to think that you didn't understand that until 2 months before trial, that you needed a mitigation specialist and that you needed to come up with a theory that you were going to present to a sentencing jury if Lori is convicted. But we have to view it from a reasonable attorney in that situation. So that's the first piece. The second piece is that you have to show that but for the lawyer's lack of effective assistance of counsel, you would have won. So in this case, they would have to say, if John Pryor had been an effective attorney for me, I would have been found not guilty. That is a really tough bar to get over. So, and the worst case scenario is that if a appellate court, the Supreme Court in Idaho, because all death penalty issues go to the Supreme Court, if the Idaho Supreme Court were to find in Chad's favor and say, you know what, Mr. Daybell, you're right. You didn't have effective assistance of counsel. What is the remedy for that? How do you fix it? You give him a new trial. Okay. So the most serious remedy would be for Chad to get a new trial. Now let's flip the coin and let's look at what would happen if Lori's speedy trial rights are violated. The remedy for a violation of your speedy trial rights is dismissal of the charges. Here's the tricky part. The Supreme Court will decide whether the violation was so egregious, was so bad, that it requires the case to be dismissed with prejudice. With prejudice, that prejudice is to the state, means they cannot refile the case. So the worst thing that could happen is that the Idaho Supreme Court could say, you violated her speedy trial rights, right, left, and center. And not only that, but it was so bad and it was so outrageous that we're going to dismiss her charges and not allow the state to bring any new charges on the same issue. Essentially, double jeopardy attaches at that point, meaning that she can't be tried again for the same crime. So when Judge Boyce is having to look at what's the worst case, what is the worst case outcome if I decide to give Chad more time? What is the worst case outcome if I decide to go forward and not violate Lori's speedy trial rights? Based on that analysis, my feeling is there's one other alternative. The other alternative is that Judge Boyce could sever the cases and could allow them to be tried separately. Judge Boyce has already ruled not once but twice on the issue of severing the defendants. And both times he has ruled that they will continue to be joined, the defendants will continue to be joined for trial. So, knowing what we know about Judge Boyce and about how he isn't necessarily the kind of guy who changes his mind or backs down, I think we can safely predict that he is not going to sever this case. If he was going to do it, he would have done it at the last motion. At this point, he's not going to sever them. The next thing then is the judge will have to decide, balancing what the worst possible outcome might be. Clearly, the worst possible outcome would be for Lori Vallow's charges to be dismissed with prejudice so that they couldn't be brought again. So my prediction is that we're going to have a trial on April 3rd. What backs this up a little bit is the fact that Judge Boyce has already denied John Pryor's motion having to do with the deadlines in the case and having to do with the January 9th deadline to file questions for the jury questionnaire. And Judge Boyce basically said, if you don't want me to consider your questions in the jury questionnaire, don't turn them in. But the 8th of January is going to be, or the 9th of January, one of those two, is going to be the deadline. And if you want your questions considered, they need to be into me by then. And I am not going to, I'm not going to extend that date. I'm not going to extend any of the dates, which sort of telegraphs what's coming at the answer to Pryor's now new motion to continue. So my prediction, reading the tea leaves, doing that analysis, looking at my crystal ball, is that we're going to have a trial that's going to go forward on April 3rd. Whether or not there are cameras allowed in the courtroom is going to be up to Judge Boyce to decide whether or not he's willing to reconsider that. I think that there's at least some compelling reasons why he might want to do that. The crowd that's going to be in the courthouse and the hardship to the families, I think those are some compelling reasons to reconsider. But as I've said before, I think there's about a 50-50 chance that he could reconsider those. Now, on Lori Vallow's part, we had a couple of new filings yesterday. They turned up in the court's database this morning. The first one is a very interesting. The first one alleges that Lori Vallow has an alibi. Now, let me clarify why let me just say why these motions are coming up now. There are certain motions, and it has to do with the judge's scheduling order, but there are certain motions that in the rules of criminal procedure have to be filed not less than 90 days before the trial. So these motions are coming up because that deadline is looming. So we saw that with the notice of that they didn't intend to allege a mental health defense. If they were going to allege a mental health defense, they had to identify the experts they were going to be calling to the prosecution 90 days in advance. So by saying we're not going to offer a mental health defense, they now don't have to provide those experts and their curriculum vitae and their reports and all of those things to the prosecution. They could bring up that issue in the mitigation phase, but in the guilt and innocence phase, they've said they're not bringing it up. So this notice of alibi is another one of those that needs to be filed within a certain amount of time before the trial begins. So, but what is really interesting here is I'm going to read this to y'all because it's short. I don't like sitting here reading documents to you. I feel like you tune in to see what I think about those documents, and you can all read the documents for yourself if you so desire. But these are short, and I think they have a couple of interesting little nuggets in them. The first one says, comes now the attorneys for the defendant, Lori Vallow, and pursuant to Idaho Criminal Rule 12.1 and Idaho Code 19519, provide notice of alibi as follows. 1. Lori Vallow was in her own apartment in Rexburg, Idaho, when J.J. Vallow and Tylee Ryan died in the apartment of Alex Cox in Rexburg, Idaho. Now, this is the first time we have ever, in 3 years, had the location of the murders identified. And so Jim Archibald is saying the murders occurred in Alex Cox's apartment in Rexburg, Idaho, and Lori Vallow wasn't there. She was with Melanie Gibb, David Warwick, and or Chad Daybell. Well, we know that Melanie Gibb and David Warwick were with her the night that JJ died. We have no idea who was with her when Tylee died. 2, Lori Vallow was in Hawaii when Tammy Daybell died at the home of Chad Daybell in Salem, Idaho. Defendant was with Melanie Boudreau and Audrey Baratario. I'm sure I've murdered that name. So interesting that her own lawyers are now saying the actual murders occurred in Alex Cox's apartment. And she wasn't there when it happened. The other one is pretty interesting as well. It is a motion for joint settlement and strategy sessions. Now, this is also filed by Lori's attorneys, Jim Archibald and John Thomas. Comes now the attorneys for the defendant, Lori Vallow, and moves the court for an order to allow the defendant and her attorneys to meet with the co-defendant and his attorney in confidential joint settlement and strategy sessions as follows. Now, in general, meetings having to do with settlement are confidential. So, 1, Lori Vallow and Chad Daybell were married in Hawaii on November 5th, 2019. On February 20th, 2020, Lori was arrested in Hawaii and extradited to Idaho. She was able to talk to her husband by recorded jail calls from the date of her arrest to June 9th of 2020, when Chad Daybell was arrested. The two have spoken by phone only one time. A lot of people have had some questions about whether or not they could communicate, whether or not they were having video chats, whether or not. I still believe they probably have been able to communicate by letter. Because those are easily monitored and redacted. And they're also easily intercepted if they're going to be used for evidence. But it says the two have spoken by phone only one time since June of 2020. And that was an arranged phone call on July 26th of 2022. So this made me wonder, why did they have an arranged phone call in July of last year? The arranged phone call was between the parties and counsel. The call was approved by the prosecuting attorney and sheriff and was not recorded. Now, this is the interesting little preface here. With settlement proposals, mediation, and motions and trial fast approaching. Let me read that again. With settlement proposals, mediation, motions, and trial fast approaching, Lori and Chad would like to be able to talk together in person and on the phone about their options. So now we're hearing that perhaps there are settlement proposals on the table. Potentially there could be mediation and or some sort of facilitated settlement conference. So in many jurisdictions, a judge who will not be the trial judge at least makes themselves available to facilitate settlement negotiations or a settlement conference. So it's possible that could be that could have been proposed. The attorneys for the parties will attend any in-person meetings and phone conversations, but will not record the conversations and will not use the conversations as evidence. The conversations can be deemed as for settlement purposes only, pursuant to Rule 408, 410, 507 of the Idaho Rules of Evidence that would apply to those conversations. And those rules essentially say that plea negotiations or communication for the purpose of settlement is confidential. So now we have some interesting information. There may be settlement talks in the works, and there may also, and we also know that Lori Vallow is going to claim that Alex Cox was entirely responsible for the murders of the children, and that she wasn't in town when it happened, relating to Tammy, and then that she was not, that they didn't occur in her apartment. So there were a few, I just want to leaf really quickly through Pryor's motion to continue because I thought one of the arguments that John Pryor makes is that there still is discovery that has not been turned over, and in some cases hasn't even been obtained by the state. Now, I want to point out that in most jurisdictions, it is not, the prosecution is not required to go to investigate your case. If you're the defense attorney and you say, okay, I want XYZ, the prosecution isn't required to have the police go out and turn up exculpatory information. That is the defense's job, to go out, to have an investigator go out and investigate the case. So it isn't necessarily the prosecution's job to go out and get evidence that they may not necessarily have. But it appears in this case that Pryor has asked for things that the prosecution has said they will get, but that he does not yet have. So that in itself is a little interesting. I just want to look through my notes and see if there's anything else. I do want to give you a little preview for next week before we move on to questions. This week, I am going to be diligently working on getting our video out for our first quilt block for the True Crime Quilt Guild. You see behind me here, I still have quilting to do. I know I have not finished my daughter's quilt, but we'll do it very shortly. Somebody asked me what kind of sewing machine I have. That is a Janome sewing machine, and it is close to 20 years old. It's my little workhorse, and I just had it cleaned and tuned up to get all ready to do this project. So look by next Friday for the first information to come out having to do with our True Crime Quilt Guild. I also want to give you a little bit of a preview for next True Crime Wednesday. We talked about some really interesting cases last week, and we'll probably talk about some interesting cases again. We'll certainly talk about any developments in the Bryan Kohberger, University of Idaho murders, and we'll look for some updates on some cases that we have been following and have talked about before. But one of the things that I would like to talk about is this new field of genetic genealogy, mining DNA evidence to create leads for law enforcement. Now, in Bryan Kohberger's case, that is not what happened. What happened was they had his DNA. They had identified him as a potential suspect. They knew that he was in Pennsylvania with his family. They were able to go through to pretend they were garbage men and go by and pick up the family garbage, and were able to find a sample in the garbage, and it was a positive match, 99.99% that the man in the home was the assailant's biological father. So that was sort of clinched them being able to get the arrest warrant, because they could connect the DNA that was found on the sheath at the crime scene with the son of the man they tested in Pennsylvania, and that was Bryan Kohberger. So that was a different sequence. But if you remember, in the Golden State Killer case, they actually mined the genetic information from some of these genetic websites, DNA websites like 23andMe and Ancestry and GenMod, I think it's called, and were able to connect up a remote relative and track back to find the Golden State Killer. That's a different question, and I want to talk a little bit about whether or not we're going to see some Fourth Amendment illegal search and seizure cases coming out of those cases, because I think it's a really interesting question. Now, the Supreme Court has said if you put your garbage out on the curb and it has incriminating evidence in it, you have given up control of that garbage to the garbage company, and law enforcement is free to come by and go through your garbage. It's fair game. But is it fair game if your second cousin twice removed does a genetic test and you are linked to your second cousin twice removed, and that is the way they find you to prove that you committed a crime? Interesting question. So we're going to talk a bit about that on Wednesday, and what some of the most current literature says about it, and what some of the pitfalls might be in the whole idea of genetic genealogy. Understanding it's a little bit different than what happened in the Kohberger case. So we are ready for questions. We are right at the hour. I am happily willing to go a half an hour over tonight. I recognize that we've tried to be really good about ending when we say we're going to, but I think at this point I'm happy to take a few questions. We'll go over by maybe a half an hour. And if I don't get to your question, I will answer them next week or in the chat. So Trisha the trucker. Hey, Trisha. If Chad had waived his right to a speedy trial at the beginning, wouldn't his lawyer have less time from start to finish than it would take for this other second lawyer to catch up? So Chad did waive his speedy trial at the beginning, and I don't know that it would. It almost is like apples and oranges. They should have brought in a second attorney months ago, brought that attorney up to speed. They should have brought a mitigation specialist in months ago, because that person is going to be working on putting together family histories. And in most cases, we're talking about medical records, employment records, mental health records, school records, going back 3 generations. So we're talking about a mitigation specialist looking at Chad Daybell and saying, I'm going to go get your grandfather's school records, your grandfather's employment records, his criminal history, his medical history, his mental health history, all of those things. And it's just a huge volume of information that has to be sorted through in order to determine whether or not anything in Chad Daybell's background would mitigate imposing the death penalty. So that should have been done months ago. It wasn't done. I think it was a financial decision. I think it was a money decision. And it's unfortunate when a defense has to run on what can be afforded. But I don't think that it's going to excuse going to trial on April 3rd. And I don't think that it is going to get Chad a new trial for ineffective assistance of counsel. T Diva says, please go go long because I got here late. Hi, Janet. Question. If they plead, I assume for life without parole, will we get to see all the evidence against them, or does that only come with a trial? No. So what the Freedom of Information Act, yes, we will see all the information. It doesn't only come if you have a trial. What the Freedom of Information Act says is that all of that information must be released once you're post-trial. So in Idaho, there is an exception to the FOIA, Freedom of Information Act rule that says that you don't get discovery until after the case has been adjudicated. Okay. So adjudication means that they have been convicted and sentenced, whether that's because of a plea or whether that's because of a trial. It doesn't matter. What matters is a conviction against them is entered on the record and a sentence is imposed. So you're right. In this case, the option for life in prison without parole only exists if it is pled down from the death penalty, or if the jury in the mitigation phase finds that there's mitigating reason not to impose the death penalty. This is a great question, Scarlett. It's beyond me. The question is, how is Lori indigent and Chad isn't, since they're married? So when you can be financially indigent, but you have to be declared indigent by the court. So you probably recall that there was a point that Mark Means, back in the day, in the Mark Means days, Mark Means filed a motion to have Lori declared to be indigent. At that point, Chad had signed his home, his real estate, over to John Pryor in lieu of attorney fees. Now, we know that that wasn't a whole lot of money, and undoubtedly that has long since been, used up. So the answer is that he undoubtedly is indigent. He's in jail. He's never going to get out again. He's never going to be able to work. He may be able to work for a few cents a day in some kind of a prison job. If there's any restitution to be paid to any of the victims, anything he were to nominal amount he would be able to earn in prison would have to go toward his victims. So he clearly is indigent. He has no source of income. Nobody's out there bankrolling his defense, but he has never applied directly to the court and said, I want the court to find I'm indigent so that I can get court-appointed counsel. You guys have such good questions. Hi, Arizona. It was foggy and rainy here today, and I have to tell you that I missed Arizona. Who does Judge Boyce answer to or refer to if he finds himself in a quandary? Would he consult anyone for advice? That is a very individual kind of a decision. I would say for the most part, lawyers happily bounce ideas off one another and often consult with other lawyers. Hey, what do you think about this? Am I right here? Am I crazy? How did I interpret this? Or how do you interpret that? Or what do you think about this? The same can be true for judges. Judges do have resources to reach out to other judges, other more experienced judges, and ask for their opinions and for their thoughts about a case. I think that it is very much an individual situation because I think there are some judges who are more likely to seek that kind of information validation. And there are some judges who are not. Just like there are some lawyers who are not likely to go out and seek other opinions. So I think it's a personal, individual sort of a decision. I would hope that Judge Boyce is talking to other judges who have done death penalty cases and who can help at least confirm for Judge Boyce that he's correct or that he's on the right track. Hi, Kathleen. Kathleen Smith asks, if Bad Lori uses Chad as an alibi, would he have to testify? Ooh, good question. Really good question. The short answer is no. Although it's possible it could get really tricky because there is this concept in the law of opening the door. So if at some point Chad or his team were to produce or provide evidence that Chad was not with Lori, then the defense Lori's team would have the right to pursue that and say, really, where were you? So there are certain instances where it is possible, but that opening the door is sort of considered to be a waiver of some Fifth Amendment right against incrimination. So in general, I would say they wouldn't be able to force him to testify because he would be able to invoke the Fifth Amendment. But that's a really good question. Louisa, Alva is the V or is the V a W? Alva? You tell me. Question. What would happen if they have found out that Chad's ex-wife didn't die of natural causes? Well, I think they very clearly have taken the position that Tammy did not die of natural causes, that her death was a murder, and that it was caused by a conspiracy that involved Chad and Lori. So I do think that that's already happened. It's clear that Tammy didn't die of natural causes, and they are charged in her murder. So I think we're already there. Hi, Linda in Texas. Who told Lori when and where the kids were murdered? They were all in Lori's apartment when JJ was supposedly taken away at her request because he was acting like a zombie. She said that. That's right. And if you remember, she was doing a podcast with David Warren and Melanie Gibb. And when Alex Cox came back in, JJ was asleep on his shoulder. in his red pajamas, the pajamas that he was later found in. So I don't know who told Lori when and where the kids were murdered. I'm sure it probably is in the discovery, or they have sort of concluded from the discovery that that's where the murders took place. Hi, Iriska. Question. First, hello. Happy Friday. Do you think this also means that maybe Lori and Chad are setting same defense strategy? I don't think so. I think that even in the most recent documents that we've seen the finger pointing going on. So I don't think that it means that they are setting the same defense strategy. I do think that it means that they want to sit down with their lawyers and talk about their options. And I don't think that's unreasonable. I certainly did co-defendant cases where the co-defendants sat down with their lawyers and we talked about trial strategy. We talked about evidence. We talked about whether or not there were defenses to the case, such as mental health defenses or self-defense or any of those other standard defenses. So it's not really unusual for them to sit down and try and talk about trial strategy. But I think if we go to sitting down and talking about options for settlement are very different than going to trial and having a knockdown drag out. So they could be quite conciliatory. They could be quite one big happy family for the settlement negotiations. And then if they cannot reach a settlement agreement and trial is necessary, they'll go at it hammer and tongs. So I don't think that's. Christine McDougall, what do they mean by settlement? Not a plea deal, I hope. That is exactly what they're talking about. Settlement in a criminal case means a plea deal. And the only issue is what that plea deal might look like. It's very clear at this point. I do not believe the prosecution is going to agree to anything that doesn't include life without parole. So the best they probably are going to get in an offer would be life without parole. Now, I have to preface that by saying we don't know everything that's in the discovery. We had a little bit of a hint way back when Rob Wood was talking with Lori's sister Summer Shiflett, and that conversation was recorded. We had a little bit of an inkling of Rob Wood at that time, which was 2 years ago, talking about how he felt like they had a stronger case against Lori than against Chad, but that he felt Chad was the mastermind. And so I don't know what that looks like now because we haven't seen any of that discovery. If the prosecution were to think that they had a weaker case against one or the other, then they might agree to a life sentence with the possibility of parole in return for the weaker defendant rolling on the one they had more evidence on. So, I mean, I've seen that kind of a situation play out before. I want to thank everybody who's donated tonight with a super chat. We really appreciate that. And I want to remind everybody that any donations, Thank you, Louisa. I want to remind everybody that any donations go directly to our moderators. So, and I think we missed a question. And I don't want people to see their questions and then for us not to answer them. So, still getting over choking on my wine. I think we've got some interesting days ahead of us. First of all, we've got a preliminary hearing coming up on Bryan Kohberger and sorry. And I'm toying with the idea of attending that one, so we'll see. And then, of course, we've got trial coming up in this case, and it is going to be very interesting to see how each trial strategy plays out. And believe me, they may be talking about a group meeting where they're going to talk about trial strategy, but once they get to trial, all bets are off. So hypothetically, if they were to take a plea deal, would we be able to see all of the discovery they plan to show at trial? Hi, Tara. Yes, the answer is yes. Once the trial is once the case, the charges are adjudicated, we will be able to see all of that discovery. We'll be able to get it under the Freedom of Information Act. So in Idaho, which is different than Arizona, which is why we got a big data dump out of Arizona. In Idaho, the Freedom of Information Act includes an exception for information that is being held pre-trial, pre-adjudication. So in this case, until there's been a trial or there's been a guilty plea and a sentencing, that information isn't available to us because there's an exception to the rule. Once there is a conviction entered and a sentence imposed, then I think we will quickly see that information. And I can't wait. I've seen kind of just in passing, I've seen several comments sort of scroll by having to do with the LDS Church. There is no question that Chad and Lori had beliefs that were based in LDS doctrine and in Mormon theology. There's no question that they had a series of beliefs that were grounded in the teachings of Joseph Smith. That is a very different, and they were both raised in the Church of Jesus Christ of Latter-day Saints, which is the mainstream church with 17 million members. I think that it is a big jump, and I have said this from the beginning, to jump from Lori and Chad were members of the church to the church writ large, the Utah headquarters of the LDS Church has in some way exerted pressure in this case or has controlled the outcome of the case. I don't think that's true. I do think that because these crimes happened in Rexburg, which is 96% membership in the LDS Church, 96% of the population in Rexburg belong to the Church of Jesus Christ of Latter-day Saints. It is a culture as much as it is a religion. It is a way of life, a lifestyle and a culture. And so I think that when we talk about whether or not the church has influence on the case, what we really should be asking is, are the people who are involved in the case so inculcated into the church that the church beliefs have an impact on how the case is prosecuted? I think the answer to that has to be yes. Yes, I believe that the people who are involved in this case are so thoroughly inculcated and thoroughly involved in the church that it has to have an influence on how the case is prosecuted. That does not mean that the LDS Church as a monolithic business organization has weighed in on the outcome of the case. Now, I have heard that on occasion, some of the higher ranking members of the LDS Church have visited Rexburg and have tried to maybe tamp down some of the emotional impact and some of the unease. But I have absolutely no evidence that the LDS Church is in any way involved directly in the case. And to be honest, my experience with people who are members of the LDS Church is they are fabulous neighbors, they are nice people, and so I don't agree with anyone who's going to come on or hop into the chat and say disparaging things about the church. I want us to be accurate and correct about our assessments. Now, I spent all of last summer reading LDS doctrine, both mainstream doctrine and offshoot doctrine. I have probably read more of Chad Daybell, Julie Rowe, Eric Smith than just about anybody else, Denver Snuffer and John Pontius. And so, I feel mildly, or at least a little bit, informed. I won't say qualified, but I will say informed enough to comment. But I want us to be accurate and specific if we're going to talk about the influence that the church has had over this over this case, because I do not believe the church has particularly had influence over the case. So that's my opinion. And I'm trying really hard to keep an open mind and to stay objective and to give you all the best information I can and write the best book I can. So, question. Michelle Monty, can you go over how many similarities jurors have to have with defendants to be peers? Or is this an older idea? Well, there certainly is the concept that you are tried by a jury of your peers. I used to always say, I don't want a jury to decide anything on my behalf because I don't think they're my peers. But I'd much rather have a judge who's got lots of experience and lots of legal acumen to decide a case. But I think in this case, you are looking for a group of people who are your everyday average citizen. They don't have to share your religious beliefs. They don't have to be your age. They don't have to be your color or your gender, but they do have to have similar values. I think that is the place that when we talk about a jury of peers, we're talking about people who have similar values. And perhaps it's an older idea as to what a peer is, whether it means, you know, your jury's not going to be made up all of moms, or your jury's not going to be made up of CEOs because you're a CEO. But I think what it does say is citizens who share similar values and believe in the importance of the rule of law and of the jury being the finder of fact. So let's just take a couple more questions because we're a little over half an hour over, and I don't want to keep you all longer. I first of all, I want to say thanks for being here. Thanks for spending your Friday night with me. There are 424 folks in chat. Please hit the subscribe and the like button. When you hit the like button, it does move us up in the algorithm. Please consider doing that. I would also like to encourage you to subscribe and to hit the notification bell, because as the trial gets closer, we're going to find ourselves having more impromptu sorts of lives. Once the trial starts, we will not be doing scheduled evening lives. I will be reporting from the courthouse. I will be dropping YouTube short videos at every opportunity to try and keep everybody up to date on what's going on in the courtroom, particularly if there aren't cameras going on in there. So it will be very important for you to get notifications so you'll know when we go live and when we have interesting content to put up. Trisha the trucker, if Pryor isn't taking other cases, how is he paying his bills? Not with a deed. You're right. And the answer is I don't know. I don't know what John Pryor's financial situation was prior, no pun intended, to the case starting. And I don't know what it is now. I know that he is sort of 50 something probably. And now I have not been watching the chat, so I don't know what this comment is about, but please, this is not a forum for arguing religion. We are going to be respectful of everyone's faith, regardless. We are going to say that we're all God's children and that we are all going to meet here and do our very best to understand these complex cases, why they happened, looking for insight into them. But I want this to be a safe space for anybody who drops in. And that includes folks who are members of the LDS Church. So I please be respectful. Min B, if they did agree to a settlement, when would that information be made public? And generally what happens is if they agree that there is going to be a plea, they will put a change of plea on the docket, and they will ask the court to put a new hearing on the schedule so that they can enter their guilty pleas. And that usually is the first inkling you get that there's been a settlement. And then from there, the judge would determine when sentencing was going to happen. Okay, Kavita, I want to be sure that we get your question because I see that you say you have asked it 3 times. And I'm sorry, our chat moves really fast and I talk too much. I just do. Michelle, Kavita Diva, I probably butchering your name and I apologize. The white Elantra was all over the news. Bryan had to know that. Why did he not dump the car? Instead, he kept it as if he wanted to get caught. I'm not sure he wanted to get caught. I think that he thought it was a common car. And we know that he changed the registration on it. So I'm not sure what to make of that re-registering of the car. the Pennsylvania license plates expired in November of 2022. So in early December, he needed to re-register the car. I suppose he had an option of re-registering it in Pennsylvania or of registering it in Washington. He decided to register it in Washington, possibly because he was concerned that he didn't want to get stopped with expired plates or draw attention to himself. But I'm sure that he also thought that switching over to Washington plates might throw them off because they may have been looking for the Pennsylvania plates. So I think he felt there were enough white cars in the world that that he was one of many, that he was sort of, swimming in the pond with all the other white cars. But it is really hard to say because he does appear to have been a person. He does appear, from what all we've seen of all the online trolling that he was doing, he does appear to be somebody who thought he was smarter than law enforcement and thought that he was going to be able to get away with it. So I think I think it's hard to say. We are only just now beginning to get a little glimmer of a view into his thinking and into his mind. We're just now beginning to think of and get a little bit of a view into the way he thinks. And so it's a little hard to say at this point whether he wanted to get caught. I doubt it. Or whether he just thought he was too smart and couldn't be caught. I'm starting to get that vibe from everything that I have heard. So I think it's possible that he just thought it was that he was just blending in. I do. Oh, Sandra D. This is a little out there, but I will answer it. I did see a question in chat, and I'm going to answer it first. Do you think that it was necessary for them to break in his parents' door with a SWAT team? I think that's kind of standard procedure because although we have the hindsight of knowing, well, they came in full force and they took him down before he could hurt anybody. We sort of have the hindsight of being able to know that it was probably unnecessary force, but police at that point didn't know that. He could have very well been barricaded in the house with an explosive device that he could have detonated. I mean, we've heard about those kind of cases. So it likely was overkill, to use a bad term, on the one hand, but I think it probably was standard operating procedure if you don't know what the mindset of the defendant is, and don't know what might be behind the doors. So let me go back to the last question. Why did they stop investigating when Chris Watts confessed? Once the law enforcement has a confession, and there are certain standards that have to be met for a confession to be valid. It has to have be corroborated by other evidence. So once they're certain that this person has given them a truthful confession, then continuing to investigate the case isn't really necessary, and more importantly, could kind of muddy the waters. So generally what happens is once there is a confession and it has been corroborated with other evidence, then the police don't investigate further. Ladybug Lady, I hope that means that you raised ladybugs for gardening. Every time I see that, I hope that that's what's going on. Question, why would they let Chad and Lori meet for strategic reasons when they're separate defendants? So they are separate defendants. The facts of the case are the same for both of them, same evidence, same witnesses. And it's not that unusual for defendants to talk to one another about what the evidence means or what their perception of a certain event might have been, what their point of view might have been on a certain event. I mean, you have an occurrence and you have maybe one person sitting on the couch and the other one in the driveway. Well, they're going to have very different perspectives on what happened in that case because they're in different places. So, I don't think it's all that unusual for people to sit down and look at the evidence and talk about potential case theories. But I actually think their request has much more to do with the issue of settlement and talking about their options in settlement. I don't think this has to do with trial strategy, because I think that if the case goes to trial, it's going to be hammer and tongs. It's going to be no holds, every other crazy thing cliche you can think of about that. It will be a cage fight. So I really think that they're hoping, I think probably their attorneys are hoping that they can get the two of them in a room, talk about the reality of the evidence, and be able to have a heart-to-heart about the reality of settlement. But we'll see what happens. Missy Bancroft, does the fact that Chad and Lori are married have any legal bearing on their cases? Are there any special privileges that they get because of it? This is an interesting question. In the state of Idaho, the marital privilege, which says that a husband cannot be forced to testify against their spouses, cannot be forced to testify against one another. This doesn't mean that they can't do it voluntarily. One spouse cannot keep the other spouse from testifying, but they are protected as long as they agree that they don't want to talk about it. There is an exception in Idaho law that if the evidence that you are trying to get the person to testify about is evidence of injury or harm to the partner's child, then, or their joint child, or one of the other. Okay, this is what happens when I go a half an hour late. Let me start again. If the evidence has to do with the children of either partner, they can be forced to testify about that over the marital privilege exception. So a lot of people have asked why Chad doesn't divorce Lori or vice versa. And I have speculated that if there is something that would be covered by marital privilege, it could have to do with Tandy's death. And it would be interesting to see whether or not they would invoke that marital privilege around Tammy's death. So, will John Pryor be ready in April? Hell no. I don't mean to be rude, but he will be as ready as he possibly can in April. Will he have done all of the best practices that the ABA recommends for a death penalty case? I would find that very doubtful, because he is starting so late. He should have started mitigation and that sort of stuff when they were first served with the death penalty notice. And he should have, you know, once again, we talked about Lori telling her lawyers that she didn't want to raise mental health issues. John Pryor can't make his client say he's indigent and get a court-appointed attorney. I sincerely hope that John Pryor has been writing cover your butt letters to Chad since the very beginning. I expect he has, because he's not a stupid guy, and he is experienced. So I would not be surprised, because he needs to be able to protect himself against malpractice or a claim that he has done something unethical because of him not being able to do all of those things that are in the best practices manual from the ABA. I think he's going to do his best. On the motions for Lori, hi, Speakeasy Lounge. Nice to see you here. On the motions for Lori, what defense saying by her not being in the apartment when the kids were killed or not in Idaho? Conspiracy is the crime. You are right. And what the alibi says is, I was not present when the children were murdered. There is no alibi that gets you out of the conspiracy part of it. So you are so right. It is pled as not only murder, but conspiracy to commit murder, and conspiracy to commit murder carries the same penalties, including the death penalty, as murder does. So I'm not, you're right, and I'm not exactly sure what Archibald is hoping to achieve by that. Maybe it's just a matter of sort of knocking the pins down. So he's saying, okay, well, I can, that this is a quick one. She wasn't there, so she has an alibi for when the children were murdered, where they were murdered, and now we can go after the conspiracy issue. So, but I suspect the state has a lot of information that we haven't seen yet about the conspiracy. So I know that you have a lot more questions. Please, my email is always in the description. For those of you who don't want to run after it, it is info@theloriVallowstory.com. And please email me with your questions. I want to assure you that every Saturday morning, I sit down with my coffee, I go through the comments below, I go through the chat, and I do look for questions and suggestions. So you can email me questions there anytime, and I will answer them. I pride myself on answering my emails, and especially on answering your questions. So I appreciate so much you all being here tonight. We've gone almost an hour over, but we have talked about two really juicy cases, really complex cases that have a lot of stuff going on about them. We're going to continue to do that on True Crime Wednesday coming up. And we're also going to talk a bit about genetic genealogy and whether or not that is going to stand up to Fourth Amendment challenges. For those people who want to really get down in the weeds and talk about the legal philosophies and sort of the more conceptual stuff. And I just want to thank everybody for being here, for hanging in with us. 396 folks still in the chat. So we will talk on Wednesday. And until then, have a fabulous weekend. TGIF. I want to remind everybody again to thank our moderators for their great work. And we'll see you all next week. Good night.